In this video, we're going to show you the 10 biggest mistakes people make when creating and managing their estate plan and living trust. They are all easy to fix or avoid, so if you are starting your estate plan or have an older plan that you're going to update, we know you'll find this information helpful. Let's dive right in. The first mistake is pretty obvious. Most people fail to create an estate plan using a revocable trust, also known as a living trust, at all. When you do nothing about your estate plan, you leave your family in the court-supervised world of probate in California. That means your assets may be tied up in legal processes, your loved ones waiting for distributions, more expense, and public records. You avoid that by creating a revocable living trust, transferring your assets into that trust, and naming a successor trustee to act when you are not able to. That work gives your family speed, privacy, and control over your wishes. The second mistake we see people making is not actually funding the trust. Creating and signing the trust agreement is only step one. If your home, bank accounts, investment accounts are still in your name rather than titled in the trust, those assets will still go through probate or at least require court-supervised steps. The mistake happens when people treat the signing like the finish line instead of the starting gate. The fix is to systematically transfer or retitle each asset into the trust, check new assets periodically, and get professional help so nothing slips through. The third mistake we see people making is having outdated beneficiary designations. Retirement accounts and life insurance policies often carry old beneficiary listings: a former spouse, a deceased child, a sibling you no longer speak to. Those designations override your trust or will and can create an unintended outcome. The stakes rise when you assume your trust or will automatically governs everything. The cure is a full review of all beneficiary designations, update them as life changes, coordinate with your trust so all pieces work together, and communicate the result. The fourth mistake we see is when people use online or generic templates to create their estate plan. California has special rules around community property, probate thresholds, tax issues, and trust administration. A one-size-fits-all template or an AI-generated form may not account for your unique state law quirks. Consider the risk around gaps, errors, untested language, and confusion for your family. When an important clause is missing from your living trust, you'll probably end up in probate. When your trust isn't created correctly, again, you'll probably be driven into probate, the expensive and time-consuming process you were trying to avoid in the first place. You protect yourself when you use a lawyer experienced in California estate planning. Tailor the trust to your mix of assets, family structure, goals, and maintain the documents moving forward. All of our estate planning documents, including those that you can create online and from the convenience of your home, are specifically tailored to you and your needs. The fifth mistake we see is naming the wrong trustee or successor trustee. Your trustee will face decisions when you cannot. If your choice lacks integrity or judgment, you set the stage for family hurt, financial loss, or conflict. Picking someone just because they share your last name or live nearby doesn't assure capability. Instead, pick someone you trust deeply. Test their willingness now. Consider professional or corporate trustee options for complex estates. Raise the conversation while you're healthy and document your selection in your trust. Number 6 is ignoring incapacity planning. If you only plan for death and skip incapacity, you leave your family exposed to court-appointed conservatorship or guardianship processes. A durable power of attorney and a healthcare directive grant authority to your chosen person now, not when things spiral. That authority gives your spouse or adult child the ability to pay bills, manage your investments, make health decisions without court delay. Make these documents part of your plan, review them with your family, and store them with your trust documents. The seventh mistake is failing to update after life changes. You tie your trust to who you are now, not who you might become. Marriage, divorce, birth, death, relocation, acquiring a business or home all change your life and your estate. A trust created 10 years ago may no longer reflect your wishes or family structure. To stay current, you schedule periodic reviews. Every few years or when life shifts, update your trust document, retitle assets if needed, and revisit your strategy with your attorney. Mistake number 8 is omitting digital assets. Your digital footprint matters. Online accounts, social media, domain names, cryptocurrency, they hold value and they hold access issues. If your fiduciary lacks authority under California's Digital Assets Act, your loved ones could be locked out. Prevent that by listing your digital assets, adding instructions and access methods, naming your digital fiduciary or successor trustee to handle them, and integrating that information into your estate plan. Mistake number 9 is over-relying on joint tenancy or pay-on-death designations. Joint tenancy and pay-on-death designation accounts are attractive for simplicity, but they carry hidden risks when they sidestep your trust and unplanned consequences follow. These avenues may bake in unwanted heirs or disrupt balanced distributions you intended. The right approach is to use them as part of a coordinated strategy with your trust, not as your entire plan. Review your titles and designations with your attorney, align them with your trust's terms, and document how everything works together. And last but not least, the 10th most common mistake is failing to communicate the plan. Your legal documents carry instructions, but your loved ones need your voice too. Silence breeds confusion and conflict. If your spouse, adult children, or successor trustee do not understand what you wanted and why, they may feel lost or hurt at a time of grief. You remedy that by explaining the core of your plan, sharing a memo or letter with your chosen fiduciaries and family, letting people know where the documents live, and creating a short conversation now so everyone moves forward from clarity. This isn't going to replace your estate plan. Its purpose is to help facilitate your plan's goals and final distribution. Your estate plan deserves to work. Your family deserves relief. If you review these 10 areas and take action on any of these things that need to be fixed or updated, you will help make sure that when you need your plan to work, your legacy will flow exactly how you intend it. If you found this video helpful, take a second to like it and check out the other estate planning videos on the channel. We're adding new how-to videos that cover just about every estate planning topic you can imagine, so hit subscribe and stay tuned for what's next. We'll also be sharing exclusive discounts and updates right here in the YouTube community, so keep an eye out for new posts and jump into the conversation when you can. And if someone you care about could benefit from what you learned today, share this video with them. You might help them protect their family and avoid the stress you just learned how to prevent. Okay, that's all for now. Keep showing up, keep learning, and never stop making each day your masterpiece.